outline for 2014 defense programs. Amendments are expected on sexual assault in the military, Guantanamo Bay, and Pentagon spending levels, along with roll call votes. Live coverage here on C-SPAN 2.
The Senator from Michigan.
Madam President, I ask unanimous consent that the time until 4 p.m. be for debate only, with the time equally divided and controlled between the two leaders or their designees.
Without objection.
Madam President, I would hope that members would now come down and debate, particularly if we can start off again with the legislation on Guantanamo. There will be two amendments here. One will be an amendment by Senator Ayotte, and the other one would be an amendment by myself with Senator McCain. It would be an 11 McCain amendment. I would hope that those who are interested in this subject particularly would come down between now and then, and that we could perhaps even reach a vote on Guantanamo, the two amendments side by side, even later this afternoon. That's the goal. It's not part of the unanimous consent proposal, but that would be a goal. And I know my friend from Oklahoma and I are able to work things out most often, and we'll try to figure out some way, hopefully, to get to votes on these two amendments we've identified as being the amendments which I think everybody agrees, not on the outcome of the vote, but agrees need to be debated and resolved. So I would yield the floor.
Madam President.
The Senator from Oklahoma.
First of all, let me say that I appreciate all the help that the chairman has given us during the course of this very difficult time. I would also suggest that we've gone through this same thing other years in the past. One of the things, there's so many people demanding or wanting to have a system where we could have more amendments, and I would encourage anyone who has amendments to go ahead and send them to the floor. It doesn't do any good to talk about them unless you have them down here and something in front of you, and then I would hope that the chairman and I could get together and we could have actually more amendments. So those people who want to be heard on this, we have adopted this timing, so we encourage you to come down and be heard. I yield the floor.
Madam President.
The Senator from Michigan.
Madam President, I want to thank my friend from Oklahoma because he has said what needs to be said here, which is that we welcome amendments being brought to the floor. We will do our best to try to clear those amendments, which means obviously consulting with not just the sponsors but potential opponents to try to see if we can work things out. On this bill, we've always been able to work out amendments, sometimes as many as 100. We need to have votes on this bill, but we also can clear amendments. We work together on a bipartisan basis to do that, and so I join in his request that the senators that have amendments get them to us to see if we can't possibly work them out. Madam President, we simply must finish this bill this week. The timetable is such that if we are going to finish this bill as we have for 51 straight years, we've got to get this bill to conference. And that is, in and of itself, will take a week.
It'd be nice.
And then we've got to bring the conference report back if we can reach an agreement on it to both houses, and that will take much of a week as well under the rules. So we really need the cooperation of every member of this body. And I will yield the floor.
President.
The Senator from Mississippi.
Thank you, Madam President. I want to rise at this point to discuss my amendment, Wicker Amendment 2185, and I think they may be bringing a podium around for me, but perhaps not necessary because I only have a few moments that I will need. But this is an important amendment, and I hope the leadership of this committee is paying attention. My amendment would prohibit foreign governments from constructing on United States soil satellite positioning ground monitoring stations. I think many Americans were surprised, Madam President, when on November 16th, the New York Times published an article by Michael Schmidt and Eric Schmidt entitled, "A Russian GPS Using U.S. Soil stirs spy fears. Let me repeat that. A Russian GPS using U.S. soil. And I ask unanimous consent that a copy of this article be inserted at this point into the record, Madam President. Do I have unanimous consent to insert?
Without objection.
Thank you, ma'am. This article elaborates on a proposal under review by our own State Department, to allow the Russian Space Agency to construct half a dozen satellite ground monitoring stations on U.S. soil. The article describes these potential sites as seemingly innocuous dome-topped antenna perched atop an electronics-packed building surrounded by a security fence somewhere in the United States. Taken at face value, these Russian ground monitoring stations are supposed to improve the accuracy and reliability of Russia's version of the global positioning system. Now, according to the Times article, the Obama administration is actively considering this request by Moscow in an attempt to reset, once again, the administration's failed reset policy, which the President once hailed as the beginning of better U.S.-Russia relations. We have every reason to be skeptical of Russia's intentions to utilize GPS monitoring stations on U.S. soil. Let me repeat this, Madam President. GPS monitoring stations controlled by Russia on U.S. soil. Time and again, President Putin has shown he is unwilling to cooperate with America. The list of grievances continues to grow. Let's not forget that Russia has granted asylum to Edward Snowden, who is charged with espionage and theft of U.S. government property after releasing up to 200,000 classified documents to the press. Let's also not forget that Russia has defended the brutal regime of Syrian President Bashar al-Assad and helped perpetuate the dictator's grip of power with military aid. And let's not forget that Russia, the same Russia that wants to put GPS stations on U.S. soil, has denied Russian orphans the chance at a better life in the United States with a ban on U.S. adoptions, ultimately victimizing the most vulnerable in a desperate attempt to distract the world from Russia's human rights failings. It's clear that Russia's interests are not often aligned with those of the United States. Accordingly, I'm deeply concerned, and people within the intelligence community are deeply concerned, and people within the Defense Department are deeply concerned about the Russian proposal to use U.S. soil to strengthen Russia's GPS capabilities. These ground monitor stations could be used for the purpose of gathering intelligence. Even more troubling, these stations could actually improve the accuracy of foreign missiles targeted at the United States. So, Madam President, our national security and foreign policy apparatus is large and widespread. I don't question anyone's patriotism or the intentions of the State Department, but it is clear that there are other parts of the administration that are very concerned about this. So this morning I had the opportunity to review a classified report by DOD. I encourage all members of the Senate to review this classified document. And to me, I think it will reaffirm the need for increased transparency on this very serious matter. Senators Lee, Fisher, and Cornyn so far have joined me in filing an amendment to the Defense Authorization Bill that would fully inform the American people about the implications of the Russian proposal. My amendment would prohibit the construction of GPS monitoring stations by any foreign government on U.S. soil until the Secretary of Defense and the Director of National Intelligence jointly certify to the Congress that these stations do not have the capability to gather intelligence or improve foreign weapons systems. My amendment would also require a report to Congress on the use of satellite positioning ground monitoring stations by foreign governments. The amendment is simple and straightforward, and I urge my colleagues to support its inclusion in the defense authorization bill, and I encourage co-sponsors from both sides of the aisle. Thank you, Madam President. And I yield the floor.
The senator from Michigan.
Madam President, on behalf of the Senate Armed Services Committee, we're pleased to bring S. 1197, the National Defense Authorization Act for fiscal 2014, to the Senate floor. The Armed Services Committee approved the bill by a 23-3 vote on June 13th, making this the 52nd consecutive year that our committee has reported a Defense Authorization Act. The strong bipartisan vote for this bill in the Armed Services Committee continues the tradition of our committee, where our members have continued to come together to support the national defense and our men and women in uniform. I thank Senator Inhofe for the major contribution that he has made to this process in his first year as the ranking Republican on the committee. This year's bill would authorize $625.1 billion for national defense programs, the same amount as the President's budget request. Unless the Congress acts to modify or eliminate the sequestration required by the Budget Control Act, however, this amount will automatically be reduced by $50 billion, leaving the Department of Defense with far less than it needs to meet the requirements of our national military strategy. U.S. forces are drawing down in Afghanistan and are no longer deployed in Iraq. However, the real threats to our national security remain, and our forces are deployed throughout the globe. Over the course of the last year, the civil war in Syria has become increasingly destructive. North Korea has engaged in a series of provocative acts. Iran has moved forward with its nuclear program, and al-Qaeda affiliates have continued to seek safe havens in Yemen, Somalia, North Africa, and elsewhere. It is particularly important that we do what we can to sustain the compensation and quality of life that our servicemen and women and their families deserve as they face the hardships imposed by continuing military operations around the world. Toward this end, our bill, 1, authorizes a 1% across-the-board pay raise for all members of the uniformed services, consistent with the President's request. Second, it reauthorizes over 30 types of bonuses and special pays aimed at encouraging enlistment, re-enlistment, and continued service by active duty and reserve component military personnel. Next, it does not include Department of Defense proposals to establish or increase health care fees, deductibles, and co-payments that would primarily affect working-age military retirees and their families. Next, it authorizes $25 million in supplemental impact aid to local educational agencies with military-dependent children and $5 million in impact aid for schools with military-dependent children with severe disabilities, and provides funding for the Department of Defense Star-based program. It enhances the Department of Defense's programs to assist veterans in their transition to civilian life by improving access to credentialing programs for civilian occupational specialties. The bill also includes funding needed to provide our troops the equipment and support that they need for ongoing combat, counterinsurgency, and stability operations around the world. For example, the bill funds the President's request for $80.7 billion for overseas contingency operations. It authorizes $9.9 billion for U.S. Special Operations Command, including both base budget funding and OCO funding. It authorizes nearly $1 billion for counter-IED efforts, beginning to ramp down expenditures in this area while ensuring that we make investments needed to protect our forces from roadside bombs. The bill fully funds the President's request for the Afghan Security Forces Fund to train and equip the Afghan National Army and Afghan police, growing their capabilities so that we can complete the transition of security responsibility as planned by the end of 2014. It reauthorizes the use of DoD funds to support a program to reintegrate insurgent fighters into the Afghan forces and into Afghanistan. It authorizes the Secretary of Defense, upon a determination from the President that it is in the national security interest of the United States, to use up to $150 million of amounts authorized for the Coalition Support Fund account in fiscal 2013 and 14 to support the border security operations of the Jordanian Armed Forces, and it extends Global Train and Equip Section 1206 authority through 2008 to help build the capacity of foreign force partners to conduct counterterrorism and stability operations. The bill before us addresses major issues that are of particular importance to the Department of Defense, including relative to the detention facility at Guantanamo Bay, Cuba, and the problem of sexual assault and misconduct in the military. As to Guantanamo, this bill would provide our military with needed flexibility to determine how long we need to detain individuals now held in the Gitmo detention facility and where else we might hold them. For a number of years now, Congress has enacted legislation eliminating this flexibility and requiring that we continue to hold all Gitmo detainees regardless of cost and whether it is needed in our national security interest. The existing legislation has made it more difficult to try detainees for their crimes and nearly impossible to return them to their home countries. For example, even if we have a strong case that a detainee has committed crimes for which he could be indicted and convicted in a federal court, the current law, existing law, makes it impossible to try him here or there. Even if we have determined that a detainee poses no ongoing security threat to the United States, we cannot send him back to his home country unless the Secretary of Defense certifies to 6 stringent conditions. And even if the individual is likely to die without advanced medical treatment, we cannot remove him from Gitmo for the purpose of receiving such treatment. As a result, the legislation that we have on the books has reinforced the impression held by many around the world that Guantanamo is a legal black hole where we hold detainees without recourse. This perception has been used by our enemies to recruit jihadists to attack us, and it has made our friends less willing to cooperate with us in our efforts to fight terrorism around the world. The Gitmo detention facility is not only a recruiting tool for our enemies, but it has become an obsolete white elephant that costs hundreds of millions of dollars a year that can no longer be justified based on the rationale for creating Gitmo in the first place. A dozen years ago, the Bush administration started sending detainees to Gitmo in large part out of a desire to avoid the jurisdiction of the U.S. courts and ensure that detainees would have no legal avenue to appeal their convictions. Whether or not one supported that approach, that argument all but disappeared in 2008 when the Supreme Court ruled in the Boumediene case that Gitmo detainees would be treated as being inside the United States for the purpose of habeas corpus appeals. Instead of recognizing that the Gitmo detention facility is no longer needed, however, we have enacted legislation which makes it virtually impossible to move detainees anywhere else, ensuring that the facility will remain open whether it is needed for particular inmates or not, or detainees, excuse me, or not. The current law prohibits the transfer of any detainee to the United States for detention under the law of armed conflict or trial before a military commission or in civilian court, and it includes these unduly burdensome certification requirements that make it extremely difficult to transfer detainees back to their home countries. The basis for these legislative obstacles appears to be the fear that returning Gitmo detainees to the home countries or transferring to the United States would pose an unacceptable threat to our national security. However, Madam President, we have brought numerous terrorists to the United States for trial and incarceration without adverse effect to our national security. In just the last 3 years, for example, we have brought 3 foreign terrorists into the United States for trial. The first is Abu Ghaith, Osama bin Laden's son-in-law, who has been convicted in federal court and remains in federal custody without incident. The second is Ahmed Abdul Qadir Warsami, who pled guilty in federal court and remains in the federal custody without incident. Third is Ahmed Galani, a Gitmo detainee who was convicted in federal court, received a life sentence, and remains in federal custody without incident. Moreover, our military has routinely detained individuals on the battlefield in Afghanistan and then exercised the discretion to transfer them to local jurisdiction or even to release them. If we can trust our military to make these determinations on a day-to-day basis, we should be able to trust them to make the same determinations at Gitmo. The risk that any of these detainees could once again engage in activities hostile to our interests around the world has been substantially reduced by the rigorous procedures that our military has instituted to review individual cases and ensure that appropriate protections are in place before transferring any detainee back to his home country. These procedures have resulted in a dramatic decline in the so-called recidivism rate over the last 5 years. While more than 160 Gitmo detainees released by the Bush administration are known or suspected to have engaged in activities hostile to our interests after their transfer or release, only 7 detainees released by the Obama administration, less than 10% of the total, are known or suspected to have engaged in such activities. This rigorous review process would be codified by the provision in our bill, which would require that the Secretary of Defense determine, prior to transferring a Gitmo detainee, that the transfer is in our national security interest and that actions have been taken to mitigate any risk that the detainee could again engage in any activity that threatens United States persons or interests. It is time for us to move past the fear that our country somehow lacks the capacity to handle Gitmo detainees and allow our military to address the transfer of detainees in a rational manner, based on the facts of each case. As to sexual misconduct, this bill includes the most comprehensive legislation targeting sexual misconduct and assault in the military ever considered by Congress. Our committee adopted more than 24 separate provisions in a host of historic, significant reforms addressing sexual assault and prevention. In particular, the bill makes it a crime under the Uniform Code of Military Justice to retaliate against a victim who reports a sexual assault, and it requires the DODIG to review and investigate any allegation of such retaliation. Our bill establishes the expectation that commanders will be relieved of their command if they fail to maintain a climate in which victims can come forward without fear. Our bill requires service secretaries to provide a special victims counsel, to provide legal advice and assistance to service members who are victims of a sexual assault committed by a member of the armed forces. Our bill amends Article 60 of the Uniform Code of Military Justice to limit the authority of a commander to overturn a verdict for rape, sexual assault, forcible sodomy, and other serious offenses. Our bill eliminates the element of the character of the accused from the factors to be considered in deciding how to proceed with the case. Our bill requires commanding officers to immediately refer any allegation of a sexual misconduct offense involving service members to the appropriate investigative agency. Our bill requires that the sentence for service members convicted of rape, sexual assault, forcible sodomy, or an attempt to commit one of those offenses include at a minimum a dismissal or dishonorable discharge. Our bill requires that all substantiated complaints of sexual-related offenses be noted in the service record of the offender. Our bill eliminates the 5-year statute of limitations on trial by court-martial for certain sexual-related offenses. Our bill codifies a prohibition on military service by individuals convicted of sexual offenses. Now, some have argued that we should also change the military justice system by removing commanders from their current role in deciding what cases should be prosecuted and instead place that authority in the hands of military lawyers. However, the testimony before our committee showed that commanders, far from being reluctant to prosecute sexual offenses, are more likely to prosecute those offenses than civilian or military lawyers. Further, removing authority from commanding officers would distance them from these cases and make them less accountable, making it more difficult for them to take the steps needed to protect victims from peer pressure, ostracism, and retaliation. While taking authority away from the chain of command would indeed be a dramatic change, this change would actually afford the victims of sexual assault less protection and make it less likely that sexual assaults will be prosecuted than the current system. For this reason, we adopted an alternative approach that will better protect victims. Our approach is to require a commander who receives an allegation of sexual assault either to prosecute it or have it automatically reviewed by his or her commander, almost always a general or flag officer, and if a commander chooses not to prosecute against the advice of legal counsel, the case receives automatic review by a service secretary. This approach will enable commanders to continue an aggressive approach to prosecuting sexual offenses while ensuring against the unusual case in which a commander might decide not to pursue a case that could be successfully prosecuted. An important part of this problem is the underreporting and inadequate investigation of sexual assaults. There is still inadequate support for victims of sexual assaults. There is also a major problem with retaliation, ostracism, and peer pressure against victims. And underneath it all remains a culture that has taken inadequate steps to correct this situation. In the end, getting this right will require sustained leadership by commanders who can be held accountable for conduct in their units. It is more difficult to hold someone accountable for failure to act if you reduce his or her authority to act. We want commanders fully engaged in the resolution of this problem and not divorced from it. Throughout our deliberations on this issue, we were guided by a single goal: passing the strongest, most effective measures to combat sexual assault by holding perpetrators accountable and protecting and supporting victims. We believe our bill does that. Madam President, our country relies on the men and women of our military and the civilians who support them to keep us safe and to help us meet U.S. national security objectives around the world. We expect them to put their lives on the line every day. And in return, we tell them we will stand by them and their families, that we will provide them with the best training, the best equipment, and the best support available to any military anywhere in the world. As of today, we have roughly 1.4 million U.S. soldiers, sailors, airmen, and Marines serving on active duty, with tens of thousands engaged in combat in Afghanistan and stationed in other regional hotspots around the globe. While there are issues on which members may disagree, we all know that we must provide our troops the support that they need. Senate action on the National Defense Authorization Act for fiscal year 2014 will improve the quality of life for our men and women in uniform and their families. It will give them the tools that they need to remain the most effective fighting force in the world. And most important of all, it will send an important message that we as a nation stand behind them and appreciate their service. I look forward to working with all of our colleagues to pass this vital legislation, and again would urge all of our colleagues who have amendments to bring them to our attention so that we can try very hard to clear amendments which can get support on both sides of the aisle and which have no strong objection. This has been a process which has worked for as many years as I've been here, and it's the only way that we're going to be able to get a bill passed this week. And again, it is critically important that this bill pass this week, or else seems to be very little hope that we could actually get a bill to conference and back to both houses. Madam President, I yield the floor.
Madam President.
The senator from West Virginia.
Madam President, I ask to speak, unanimous consent to speak for up to 5 minutes, and after I conclude my remarks, I ask for Senator Chambliss to be recognized, followed by Senator Ailes.
Without objection.
Madam President, I request also that consent that Dan Gilbert, my Department of Defense fellow, and Erica Miller, my State Department fellow, be granted floor privileges for the duration of the National Defense Authorization Act through final passage.
Without objection.
Madam President, I rise to highlight for senators the important work of the Airland Subcommittee in the fiscal year 14 Defense Authorization Act as reported by the Committee on Armed Services. I'm proud, very proud, to be chairman of the Airland Subcommittee and for the close working relationships that I have with Senator Wicker, the ranking member of the subcommittee. The Airland Subcommittee has broad responsibilities for substantial parts of the Army, Navy, Marine Corps, and Air Force budgets. The Airland Subcommittee also has responsibility for National Guard and reserve equipment and readiness. As a former governor, I know firsthand how effective the National Guard is, and they provide a great value for all Americans. Throughout this process, the goal of the Airland Subcommittee has been to promote and improve current and future readiness of our military, all while ensuring the most efficient and effective use of taxpayers' dollars. This year, the Airland Subcommittee has jurisdiction over $49 billion of the Defense Department's base and overseas contingency budget. This includes $37.1 billion for procurement and $11.9 billion for research and development. In this regard, the Airland Subcommittee's recommendation fully supports the Department's budget request for overseas contingency operations and would support most of the major weapons and equipment programs in the base as requested. However, sequestration presents many challenges. We can no longer spend billions of dollars buying equipment that the military does not need or want. Just a few days ago, the Chairman of the Joint Chiefs of Staff, General Dempsey, provided me with a list of programs that the Department of Defense no longer needs or and they want to retire. This much is clear. We can no longer conduct business as usual. In fact, the Bowles-Simpson Commission recommended the Department of Defense and Congress establish a commission that would review major weapons programs unneeded by the Department. This is something we should take a look at, and I look forward to working with my colleagues on this important issue. And the Commission on the structure of the Air Force is already reviewing and will make recommendations on the retirements and divestitures of aircraft the military no longer needs. In future subcommittee work, I will be reviewing General Dempsey's list and will be working with my colleagues on the programs that the Department no longer needs. Congress must debate this important issue so that we spend every dollar we have wisely and keep our military the strongest in the world. I want to compliment Senator Wicker again on how well I think that we have worked together this year, and thank Chairman Levin, Ranking Member Inhofe, and the wonderful committee staff who have worked so closely with my staff and me on this bill. Madam Chairman, Madam President, thank you. And I yield the floor.
Madam President.
The senator from Georgia.
Madam President, first of all, let me say that to my friend from West Virginia, I happen to serve on that subcommittee, and I was in the hearing the other day when he asked a question of General Dempsey, very appropriate question. We thought a very strong answer was going to be given by General Dempsey to the senator from West Virginia's question regarding weapon systems and other expenditures that are mandated by Congress that the chiefs and other folks at the Pentagon have said they don't need. And as he and I were just discussing, we finally got that letter yesterday, and it was somewhat of a very tepid response rather than the strong response that we had hoped for. But in any event, the senator from West Virginia, along with Senator Coburn and myself, are going to work together to develop a list of expenditures that either are unwanted by the Pentagon that Congress has mandated, or expenditures that ought to be spent in some other agency but unfortunately is being charged to the Pentagon. So I do look forward to working with him on that issue, and I thank he and Senator Wicker for their leadership on that subcommittee. I rise principally today, Madam President, in support of the Ayotte-Chambliss-Inhofe Amendment number 2255, which would restore many of the legislative limits and requirements that Congress has placed in recent years on the transfer of Guantanamo Bay detainees and prevent medical-related transfers to the United States. I believe these legislative safeguards are vital to our national security and essential to good intelligence collection. For several years now, we have been debating the status of Guantanamo Bay and the detainees who remain there. Time and time again, in the course of these debates, I have asked this administration to come up with a viable long-term detention and interrogation policy. And frankly, they have failed to do so because of a stubborn commitment to a poorly thought-out campaign promise to close Guantanamo. The call to close Guantanamo may sound like a good campaign soundbite to some people, but frankly, in the real world of national security, it undermines good intelligence collection and increases the risk that dangerous detainees will be back on the streets where they can continue, as they have, to kill and harm Americans. These are not abstract theories, they are facts. The recidivism rate is nearly 29% and has been climbing steadily since detainees began being released from Guantanamo. This includes nearly 10% of detainees who have returned to the fight after being transferred by the current administration, following the administration's extensive review of each detainee. Al-Qaeda in the Arabian Peninsula counts former Guantanamo detainees, not just among its members, but among its leaders. A former Guantanamo detainee is believed to have been involved in last year's Benghazi attacks that killed our ambassador and 3 other Americans. The administration's stubborn refusal to add even one more terrorist to the Gitmo detainee population has forced the executive branch back into the pre-9/11 mindset of treating terrorists as ordinary criminals, a mindset that we know doesn't work. Now, a lot of people will come to this floor on the other side of the aisle and say that, well, we have tried all these terrorists in Article III courts in the United States, and it has worked. For the most part, they have been convicted and they're now serving time. That's a fairly accurate statement, except what they fail to say is that these Article III trials of terrorists that have been arrested inside the United States are nowhere near the caliber of those who planned and carried out the attack of 9/11, as well as those who were captured on the battlefield seeking to kill and harm Americans, and in a lot of instances did kill Americans and maim Americans that are now housed at Guantanamo Bay. That is a very, very distinct difference, and those prisoners should not be treated the same as an ordinary common burglar is treated in an Article III court here in the United States. In response to valid criticisms of the approach that the mindset of 9/11 is being returned to, the administration now seems to favor interrogations on board naval vessels. The end result, however, has been no different. At the end of the day, these brief interrogations, at the end of the interrogations, those individuals have been transferred to federal courts here in the United States, where they are unlikely to provide any more intelligence information because they have been Mirandized and are now awaiting trial. From the Christmas Day bomber to the Boston bomber to the East Africa Embassy's bomber, this preference for criminal prosecution at the expense of intelligence collection has become the administration's standard operating procedure. This is no way to defend our nation, and it sends a message of weakness to terrorists and our allies alike. This amendment that Senator Ayotte, Senator Inhofe, and I are putting forward sends the right message, number one, to the American people. It ensures that our detention practices have clarity for the next year and that on a permanent basis no detainee will be transferred overseas unless there is a clear certification that the transfer is in the best interest of the United States. This also sends a very clear message to the terrorists at Guantanamo Bay. You are not coming to the United States where you will have the advantage of Article III courts. This amendment includes 5 provisions. Number 1, it imposes a 1-year ban on transfers to the United States of Guantanamo detainees except in cases after the date of enactment where the detainee is sent to Guantanamo for purposes of interrogation. 2, it imposes a 1-year ban on transfers of detainees to Yemen, and I'll talk more about that in a minute. It imposes a 1-year ban on building or modifying facilities inside the U.S. to house Guantanamo detainees. 4, it makes permanent the certification requirements needed before any transfer of a detainee overseas. And lastly, it strikes the provision in the bill that allows transfers of detainees to the United States purely for medical care. Let me address each provision very briefly. First, I have yet to hear why it's a good idea to bring Guantanamo detainees to the United States. While the President made a promise to close Guantanamo, the American people seem unified against bringing these detainees to the U.S. for any reason, and I believe that we should listen to the American people. It's clear that given the Secretary of Defense the authority to decide to bring detainees here for detention, trial, and incarceration will have the same impact as Congress lifting the prohibition outright. But the same issues we have been talking about for several years and that GAO identified in its 2012 report on detention options inside the United States still exist. These include cost considerations, questions about the legal status of the detainees, and concerns about protecting the general public and personnel at these facilities or during trial. Now, let's look at who these 164 individuals are that remain at Guantanamo. We started out with about 860-something, as I recall, give or take a few. So we have already released, both to other countries and in some cases where we frankly made a mistake, individuals who should not have been there, or it has been determined by the appropriate reviewing committees that these detainees were okay to be sent back to their country of origin or to some other host country that was willing to take them and supervise them or keep them in detention, but to get them out of Guantanamo. Now, the 164 that are remaining are the meanest, nastiest terrorists in the world, frankly. They're the ones that nobody's going to want. So if nobody else wants them, why should we allow them to come to the United States? These are the individuals that either planned and masterminded the attack on the United States on September 11, 2001, such as Khalid Sheikh Mohammed, or they're individuals who we picked up on the battlefield who were actively engaged in fighting and killing Americans, as well as engaged in building bombs that were intended to, in a lot of instances did, explode and either kill or injure Americans. Now, some of these folks range from KSM to the USS Cole bomber who are awaiting trial and, frankly, should be tried at Guantanamo. In other words, they are dangerous detainees who should not and cannot be sent, as I said, to any other country. Now, many of us have been calling on the administration to send new detainees to Guantanamo simply for interrogation. Detainees like al-Shabaab leader Ahmad Abdulkadir Warsame, East African Embassy's bombing suspect Abu Anas al-Libi, who was arrested in Libya recently, and suspects in the Benghazi attacks, all belong at Guantanamo, where they can be interrogated for a long time under the rules and articles of war, without Miranda rights or criminal defense lawyers. But this administration has consistently refused to even consider Guantanamo for interrogation of the meanest folks who still remain at large. It's off the table, as they tell us. Some have used the excuse that it's off the table because of this restriction in previous defense authorization acts. In other words, the administration could not put any new detainees at Guantanamo for interrogation because they could not send them to federal court for trial. If this administration had made any effort at all, even just once, over the past 4 years to interrogate detainees at Guantanamo rather than holding them on a ship, this excuse would have much more merit. But to make sure that there are no excuses anymore, our amendment makes clear that detainees who are sent to Guantanamo specifically for the purposes of interrogation after the date of enactment may still be transferred to the United States for trial in Article III courts or before military tribunals. That means there is absolutely no need to hold another detainee on board a ship just to interrogate him, and there is absolutely no excuse for not putting new detainees at Guantanamo Bay. This provision makes sense for the security of this country, and it makes sense for good intelligence collection. Now, the ban on transfers to Yemen is a very critical aspect of this amendment. The amendment bans any detainee transfers to Yemen until December 31, 2014. It's been 4 years since the President imposed a moratorium on transfers to Yemen from Guantanamo following the failed airplane bombing attempt on Christmas Day 2009 by Umar Farouk Abdul Muttalib. At that time, Yemen was viewed as a hotspot for terrorists, especially with the rise of al-Qaeda in the Arabian Peninsula. Now, 4 years later, not much really has changed except for the rising recidivism rate. We know that former detainees have rejoined AQAP both as leaders as well as members. We know that former detainees have we know that Yemen continues to struggle with terrorist groups who are trying to make sure it remains an AQAP stronghold. And we know that AQAP continues to look for ways like the 2009 failed Christmas Day bombing to attack this country. We have seen all the reports that the administration wants to transfer detainees to Yemen and is working with the Yemeni government to set up a detention or rehabilitation facility inside Yemen to house these prisoners. We learned from the Saudi rehabilitation program that rehabilitating hardened terrorists simply doesn't always work. The recidivism rate for the Saudi program is at least 20%. Many of these detainees, like AQAP leader Saeed al-Sahiri, ended up in Yemen fighting as terrorists again. Yemen, as one senior administration official described it, is like the Wild West. It's the last place we should send dangerous detainees. In other words, now is not the time to experiment with our national security. Mr. President, our amendment ensures that no detainee can be sent to Yemen over the next year. I recognize that there are Yemeni detainees who have been cleared for transfer, so we do not permanently prohibit those transfers. But just because a detainee is eligible for transfer from Guantanamo does not mean he no longer poses any threat at all. We have to remember that the easiest transfers have already been done. And even among those easy transfers, over a quarter of them have been known to be re-engaged in the fight against Americans. So our amendment imposes a reasonable time period on this prohibition. No transfers can occur until at least December 31, 2014. Over the next year, we should have a better sense of how well the Yemeni government is combating terrorists within its borders. Once we see their track record, we can decide whether it makes sense to send them any new detainees. In the past, under the previous government of Yemen, the detainees who were transferred from Guantanamo to Yemen simply were allowed to wander around in Yemen with no supervision whatsoever. And I dare say that we now do not have any idea where most of those detainees are inside of Yemen, or, more significantly, whether they're still in Yemen, whether they're re-engaged in the fight, whether they're in Syria, fighting on one side or the other, or what's going on with those detainees. Al-Qaeda and its affiliates look up to Guantanamo detainees. They have immediate street credibility among terrorists, which makes it more tempting for them to rejoin the fight. We should not make it easier to transfer detainees anywhere, much less places where there are confirmed recidivists or a real threat from AQAP. The detainees, including many of the Yemenis who remain at Guantanamo, are among the worst offenders. We should want all future transfers to be done wisely and fully in line with our national security interests. This amendment accomplishes those objectives. Thirdly, this amendment continues the ban on building or modifying facilities inside the United States to hold those detainees. It does not prohibit any changes to the facilities at Guantanamo Bay, so those facilities will continue to be state-of-the-art. I understand this administration wants to close Guantanamo and that the Justice Department has already purchased the correctional facility in Thompson, Illinois, to house them. But there is still overwhelming consensus here in Congress and among the American people that Guantanamo detainees should never set foot inside the United States. We need to listen to that consensus. So with that in mind, our amendment ensures that not one penny of American taxpayer dollars will be spent on the Thompson facility or to build or modify any other facility inside the United States to house Guantanamo detainees. Our amendment applies not just to Defense Department funding, but to all U.S. government funds. That way, no other department, including the Justice Department, can try to circumvent the will of the American people and bring Guantanamo detainees to our homeland. Many of us have been to Guantanamo. I've been there several times to see for myself how the detainees live and are treated. It's a first-rate prison facility, and I have been to many prison facilities in my state as well as other parts of the country. It's one that would probably make most inmates at prisons here inside the United States very envious. We should not forget that many of the detainees at Guantanamo are some of the most dangerous terrorists in the world. If they can't be transferred to other countries, they don't belong in the United States. This amendment also makes permanent the certification requirements that are needed before any detainee can be transferred outside of Guantanamo Bay. As I mentioned, the recidivism rate today is almost 29% and growing. So we should not make it easier to transfer detainees anywhere, much less to places where there are recidivists or real terrorist threats. The certification requirements and ban on transfer if there is a confirmed recidivist in a host country were designed to lessen the likelihood that detainees would reengage. I understand some people want Guantanamo closed, but eliminating common sense measures that are there to protect American citizens is not the way to do it. These measures give Congress and the American people confidence that the Defense Secretary has fully considered all aspects of the transfer, especially the host country's past record and current capabilities. As the rising recidivism rate tells us, even detainees who have been cleared for transfer through a very rigorous process, I might add, can still pose a threat. We have to remember that the easiest transfers have already been done, and even among those, over a quarter have reengaged. The detainees who remain are among the worst offenders. We should want all future transfers to be done wisely and fully in line with our national security interests. I don't find persuasive the argument that these certification requirements are so burdensome that detainees can't be transferred. In fact, this year alone, detainees have been transferred to Algeria, and we continue to get notices of other proposed transfers. Not every detainee needs to stay at Guantanamo Bay. I recognize that, as do the other authors of this amendment. But not one should be released until we are absolutely certain that everything is being done to prevent new terrorist activity on the part of those individuals who are in fact released. These certification requirements give us that certainty. Making these requirements permanent is the only sure way to guarantee that each and every transfer is the best thing for the national security of the United States. Finally, this amendment restores the status quo by striking Section 1032 in the bill, which allows the transfer of detainees into the United States for medical care. We need to remember that Guantanamo is a first-class facility operated by dedicated military personnel who put up with an awful lot from detainees. I remember the first time I went to Guantanamo, they were housed in a facility that is not the facility where they're in today. And it was much more of an open facility where the guards simply would walk back and forth in very close range to the actual prisoners themselves. Those guards were subjected to being spit upon, having human waste thrown at them, as well as food or anything the detainees could get their hands on. And needless to say, it was not a very nice place to be. But we need to remember also that Guantanamo possesses not only first-class medical facilities, but also first-class judicial facilities for the trial of these individuals. There is a state-of-the-art courtroom down there that is being virtually unused today that ought to be used to try these individuals before a military tribunal. Section 1032 seems to be a solution in search of a problem. Guantanamo Bay has the facilities from a medical standpoint and the doctors within the military to treat these prisoners. And I'm not aware of any instance in which a detainee has died or suffered further injury because of our inability to treat them at Guantanamo. Aside from being unnecessary, this provision does not make good policy. Over the past several years, detainees at Guantanamo have waged repeated hunger strikes in an effort to gain sympathy so the United States will release them from prison. When inmates in our prisons here engage in such tactics, we don't reward them. But that's exactly what Section 1032 would do. If we give detainees the ability to be brought to the United States, even for what is supposed to be temporary treatment, that's a powerful incentive for a detainee to injure himself or go on a hunger strike. I'm also concerned about how this provision would even be implemented. It's unclear whether we will have to modify military hospitals so they can handle high-value terrorist detainees. At what cost and at what risk to the safety of others, including the towns in which these facilities are located. I appreciate that the provision tries to limit the rights of detainees when they are brought here, but we have been down this road before with habeas corpus rights. Once a detainee is physically inside the United States, it becomes much more difficult to argue against any change in immigration or legal status. In my view, Section 1032 is simply in this bill to further reduce the population at Guantanamo. This is not a goal that I can support. Our amendment keeps the status quo and keeps these terrorist detainees where they belong, at Guantanamo Bay. Now, it's time for this administration to provide real leadership on detention and interrogation issues instead of trying to keep ill-conceived campaign promises that run contrary to the established facts and known threats to our national security. Keeping this country safe demands real-time intelligence, the kind we have gotten in the past from interrogating detainees for long periods of time, including those detainees at Guantanamo. It is time for us to end this dangerous practice of treating terrorists first and foremost like criminals who deserve Miranda warnings, attorneys, and court appearances. It is time for us to stop pretending that the detainees at Guantanamo are no different from common, ordinary criminals. Our amendment ensures that the balance remains on the side of our national security and good intelligence collection. It ensures that common sense, not politics, will determine the future of Guantanamo detainees and the effectiveness of our intelligence collection. And, Mr. President, I'm pleased to now turn to the Senator from New Hampshire, Senator Ayotte, who has been such a champion on this issue. She and I have worked very closely on this as well as any number of other national security issues. Since she came to the Senate, she's been a tremendous asset. Being a former prosecutor, she understands how serious these individuals are from a criminal standpoint. I commend her for the great work she's done, and I certainly look forward to hearing her comments now.
Thank you so much. I very much appreciated, Mr. President, sorry, may I be recognized?
Senator from New Hampshire.
Thank you. Mr. President, I first of all want to thank my